Go on.
Good afternoon, Mochineke, from wherever you are. Greetings from me, Barrister Fine Jofo, the Council to IPOB. First of all, before we proceed to update Mochineke on the outcome of today's proceedings, it's pertinent and compelling on the part of Mochineke to also observe a 1 minute silence for the death of our elder statesman, Chief Chukwuemeka Ezeife, who we informed the court today that passed on yesterday. So let's observe 1 minute silence in his honor. May the soul of our daddy, Chukwuemeka Ezeife, Chief Chukwuemeka Ezeife, rest in the will of our Lord Jesus Christ. Today, as you are aware, we are very expectant of a positive outcome in court today on Supreme Court. But we are not pleased. We are unhappy. As you are aware, no Biafrans are unhappy today. We are very unhappy and dissatisfied. But of course, Supreme Court is the final court of the land. We cannot question them. The matter actually came up today for judgment, and I will give basic highlights in line with the court's assessment of facts and pronouncements. But the court didn't go into detail of judgment because of the time constraint. So when we get the judgment and look at it, we'll probably give further information to the public and Biafrans. First of all, the court, in discussing the merit of the case today, appeal before the court, said observed and roundly condemned the invasion of Mazi Nnamdi Kanu's premises on the 14th of September 2017 by the agents of the state, Nigerian security agents. The court condemned the invasion of his premises on that day. The court rightly observed that then Mazi Nnamdi Kanu was facing trial before the Federal High Court and was granted bail. That if in the course of enjoying the bail granted him by the court, by the Federal High Court then, and the fact that he's in Nigeria, that he is to be binded by Nigerian law. So according to the court, that that he cannot, he is to be allowed to face the trial before the Nigerian law. That can no longer be allowed to go scot-free, as in to take advantage of the manner in which he was abducted in gross violation of his right. However, that you can maintain civil action against the authority, the state government, the federal government, on the manner in which his right was grossly violated, that can give rise to civil action. That's what caused the substance. And consequently ordered the matter to the trial to commence before the Federal High Court. So as you are aware, because it's important for me to explain, that before the Federal High Court was 15 count charge that was sometime before preferred against Onyendu Mazi Nnamdi Kanu. And in view of the frivolous nature of the charge and the emptiness of the charge, an objection was raised by the defense team led by Professor Michael Zekomen to the competence of the charge, and 8 count out of 15 count charge was struck out by the Federal High Court. So remaining 7 count charge. So being dissatisfied with the remaining 7 count charge, an appeal was filed against that 7 count charge before the Court of Appeal. So by we defense counsel led by Professor Michael Zekomen. So, and on October 13th, 2022, the Federal High Court delivered a sound judgment. The Court of Appeal delivered a very landmark judgment, a unanimous judgment indeed, and consequently struck out the remaining 7 count charge in allowing our appeal, and further directed that Mazi Nnamdi Kanu will not be tried before any court in Nigeria again, or even detained further, and directed the federal government to release him unconditionally. So this were the judgment of the Federal Court of Appeal delivered on the 13th of October 2022. Federal government being not satisfied that judgment filed appeal before the Supreme Court, for Supreme Court to dismiss the judgment of the Court of Appeal. So that was the decision of the Supreme Court today. After this observation I earlier mentioned, the court proceeded to allow the appeal filed by the federal government and directed that trial should start. So we're going back to Federal High Court any month from now to start.
Is it for a normal trial?
For trial with I have 2 questions. Number 1 question is, to my understanding, I believe so much that the Supreme Court is the final stage or the higher level of judiciary. So why referring them to Federal High Court, since the Supreme Court is the high authority? That's number 1.
This question has been asked by someone before now, and it's important for me to clarify before going to the second question.
Okay.
So I will take that question along with the one you asked about whether it's going for a waiting trial. Of course, you know that before now, what we have before the Federal High Court against Onyendu Mazi Nnamdi Kanu is a 7-count charge. Because out of that 15, the court struck out 8-count charge, remaining 7. So, of course, you know that at the point an appeal was filed against that 7-count charge, remaining 7-count charge before the Court of Appeal, that the matter was still live before the Federal High Court. So, because it was adjourned then for a report of proceedings before the Court of Appeal. So, on 13th of October, when the matter came up, when the judgment was delivered by Court of Appeal, and consequently allowed our appeal, we eventually went back to Federal High Court to report the judgment of Court of Appeal. So on the day we went back to Federal High Court to report the judgment of Court of Appeal, the court was addressed on the outcome of judgment before the Court of Appeal, and court consequently adjourned that matter till the day. So that means the court didn't give a date. The matter will be coming up because the court is waiting for the outcome of judgment of the Supreme Court as the final court of the land. Because once the Supreme Court, even the Supreme Court that disputes the appeal today, that will be the end of the case. So the fact the matter was adjourned till that shows that element of life on the 7-count charge before the Federal High Court, which yes, of course, which though has been struck out by the Court of Appeal, they still like because the appeal process stay on until when consummated. Like now it was consummated today, the appeal has been decided and they are allowed by the Supreme Court. So we are not going back now to activate that 7-count remaining charge, which was
on the normal trial.
On the first, yes, formal trial. So which was not before the trial, before the Federal High Court. So because that matter now adjourned in this indefinitely will now be called up now. So it will need the prompting of the prosecution, which ordinarily if you allow them now, they will probably go to sleep. So we all are going to follow it up to ensure that letters by between now and Tuesday, a date is given for the matter to court.
For normal hearing.
Yeah, for normal hearing on the matter.
Yeah. Okay, number 2 question, which is my last question. Unlike before, Mazi do appear before the court, but today, why did Nnamdi Kanu not appear physically?
Thank you. You know what is before the Supreme Court is what is before the Supreme Court is an appeal against the judgment of Court of Appeal. It's only in limited circumstances that an appellant will be allowed to appear in court himself. Though we made an attempt to ensure that he's in court to hear, to at least to know what's being decided against him for the Supreme Court, but it's an onerous procedure for him to be allowed to be present in court, particularly when the trial is not going on, because it's an appeal that's being had. Like now we're going back to the Federal High Court now. He must be present at any day the matter is coming up for the trial. You must not have sent. Any day is not in court, the matter will not go on. So you must be present on any day the matter is, because trial is not coming up before the Federal Court for trial, full trial. Yeah. So you must be present on any day the matter is coming up before the Federal Court for hearing. Okay. So it's just an appeal process. This is a judgment that was granted by delivered by the Court of Appeal. That's a discussion about the substance of the judgment. So, and these are far-reaching pronouncements by the judges of Court of Appeal judgment. So the federal government quickly, upon judgment being delivered, filed an application for stay of execution. So though as unprecedented as it is, the Court of Appeal sitting presided over by a different panel of justices of the Court of Appeal granted that application, and the judgment was stayed, and they relied on that order, staying that execution of the judgment of the Court of Appeal. Not that the terms of judgment of the Court of Appeal. So before proceeding on appeal. So the decision of the Supreme Court today was on the merit of the appeal. Actually, my Lord Justice that delivered the Supreme Court today before the Supreme Court didn't delve into the substantive argument, findings, and conclusions before the court. Just went into decision, the court decision of the Supreme Court, and possibly highlights, as I pointed out, and before probably making pronouncement as to the decision of the Supreme Court.
Okay. So the other message I have for you now is, the question I have for you now is, do you have any message for the common man from the Southeast? Because due to the situation in Southeast currently, I assume that everywhere is under panic. People are afraid, people are not comfortable, and if you look at it from the larger picture, you see that many of our people will not come home for Xmas due to fear or panic of one thing or the other. So is there any message you have, not directly from Mazi Nnamdi Kanu, but maybe from your own point of view? What advice or message do you have for our people, sir?
Okay, speaking as a lawyer, number one, I'm also as a lawyer to IPB Legal Counsel. I want to emphasize that no matter the effort, point in time, I would advise ultimate restraint. What I know for sure is that Mazi Nnamdi Kanu will be out. We have gone through the charge meticulously between lines, even the one they amended and filed. And so we have gone through them. And I know that they cannot effectively substantiate that charge during trial. And we also intend, because Nnamdi Kanu is medically unfit to face the trial as it stands today, because I'm the one that's been visiting him with doctors to at least to attend to his theoretical mental health condition. So first of all, he has to be attended to medical wise. And so in that case, we'll be talking about him being granted bail as soon as the case is called up. Because you have to be sound health-wise before you can face trial. Yeah. So once the charge is called up, any month from now, an application for bail should be also filed. Because we have his full medical records and recommendation by his medical doctors that require him to even attempt to undergo advanced medical treatment outside this place. So these are compelling facts I'm going to bring to attention of the court, because it's only a living person that can stand trial. So, and as it stands today, based on documents available, medical documents available to him and also to the SSN, they have it, that can be competent to stand trial, because it has to go and attend to medical situation. That's number one. So, and on that note, I advise our people to apply greater restraint. This is what I can say as a lawyer. But I can't advise people to go into violence and protest. I won't say that. What I will say is restraint. Believing that the will of justice may be delayed, but in the end, there will be happiness. And we're not leaving anything on stone to ensure that he's giving the best of representation. So at least he has a very erudite advocates in the matter. So thank you. That's all I can say for now.
Okay. I don't know if I should just throw one last something to you, because it is very, very important. When you are in a jungle where it is critically assumed as a palace, but you inside your heart, you know that this is a jungle. Nothing better may come out of a jungle. This is just a parable. Now, taking some few points from my illustrations now, I want to bring it to reality. Do you think it is possible the same courts, the same federal high courts, would grant bail to...
No, let me just, I don't want you to print the outcome of the application. It's an application that will come live before the court. I wouldn't want to discuss that, because I know that when we get to the bridge, we cross it. And I know what we have before us, that they are not privileged to. When it has to do with medical documents. So, and I may not be able to discuss the substance of it now.
Okay, sir. So, is anyone influencing the release of Mazi Nnamdi Kanu not to be possible from your own idea, or is there any information you've picked like that?
You know what I can talk here is law. So I don't want to talk politics, or anything outside law. So what I'm discussing with people is law. I don't want to go into political aspects. So probably maybe some people can discuss the political aspect of the case, but I'm talking law. Okay. And anything but law. Thank you so much.
Thank you very much.
Thank you, the Lord.
And God bless you.
The fact that he's in Nigeria, that he is to be binded by Nigerian law So according to the court, that that he cannot, is to be allowed to face the trial before the Nigerian law. It can no longer be allowed to go scot-free, as in to take advantage of the manner in which he was abducted in gross violation of right. However, that you can maintain civil action against the authority, the state government, the federal government, on the manner in which his right was grossly violated, that it can give rise to civil action. That's what caused the substance. And consequently ordered the matter to the trial to commence before the Federal High Court. So as you are aware, because it's important for me to explain, that before the Federal High Court was 15 count charge that was sometime before preferred against Onyendu Mazi Nnamdi Kanu. And in view of the frivolous nature of the charge and the emptiness of the charge, an objection was raised by defense team led by Professor Michael Zekome to the competence of the charge, and 8 count out of 15 count charge was struck out by the Federal High Court, so remaining 7 count charge. So being dissatisfied with the remaining 7 count charge, an appeal was filed against that 7 count charge before the Court of Appeal. So
by the federal government.
by us, by we defense counsel led by